Companies Act Section 60, Publication of Authorized, Subscribed, and Paid-up Capital. 1. Overview of disclosure requirements for company capital information. Section 60 of the Companies Act establishes guidelines for the publication of a company's financial data, specifically related to its capital structure. This section outlines that when a company publicly shares information about its authorized capital, it must also clearly state the subscribed and paid-up capital amounts. Such disclosures are crucial for maintaining transparency with stakeholders and ensuring accurate financial representation. 2. Requirements for capital disclosure in official publications. When a company releases any notice, advertisement, or other official publication that references the amount of its authorized capital, it must also prominently disclose subscribed capital, the portion of the authorized capital that shareholders have agreed to purchase. Paid-up capital, the amount actually received from shareholders, reflecting the capital that has been fully paid into the company. This dual disclosure must be displayed in an equally prominent position and with equally conspicuous characters as the authorized capital amount, ensuring that stakeholders and readers are not misled by an inflated representation of the company's financial capacity. For example, if a business letter or billhead includes a mention of authorized capital, the subscribed and paid-up amounts must appear alongside it in an equally visible and readable format. 3. Specific instances requiring compliance. Section 60 requires companies to adhere to these disclosure standards in various forms of communication, including notices and advertisements, any public announcements, whether online, in print, or on other media, where authorized capital is mentioned. Business letters and billheads, commonly used business documents that may reach investors, partners, or clients must reflect accurate capital information. Official company publications, any publication by the company, intended for public or stakeholder viewing, must include this information if it references capital figures. By ensuring that accurate capital data is shared consistently, Section 60 helps prevent any overstatement or misinterpretation of a company's capital resources in its communications. 4. Penalties for non-compliance with capital disclosure requirements. Failure to comply with the disclosure requirements under Section 60 can lead to legal consequences for both the company and its responsible officers. Company penalty. If a company omits the required subscribed and paid-up capital details alongside its authorized capital, it will incur a penalty of 10,000 Indian rupees for each instance of non-compliance. Officers' penalty. Each officer of the company who is found to be in default will also face a penalty of 5,000 rupees per instance of non-compliance. These penalties underscore the seriousness with which Section 60 treats transparency and truthful financial representation, encouraging companies and their officers to follow strict adherence to capital disclosure regulations. 5. Purpose and importance of Section 60's disclosure standards. The regulations established in Section 60 aim to promote transparency. By providing accurate and full disclosure of a company's capital, stakeholders gain a clearer understanding of the company's actual resources. Prevent misleading information. Ensuring that the subscribed and paid-up amounts accompany the authorized capital prevents stakeholders from assuming that all authorized capital has been issued and fully paid. Strengthen corporate governance. By holding officers accountable, Section 60 enforces responsible governance and aligns a company's public information with its real financial status. These measures help potential investors, creditors, and partners make informed decisions based on accurate and complete financial data.